Can I challenge a low property damage offer after a car accident if my vehicle had major repairs? Yes, you can usually challenge a low offer if the insurance company has not fairly accounted for repair costs, rental costs, loss of use, diminished value, or reimbursement issues. After major repairs, the question is not just whether the body shop was paid. The question is whether the total payment fairly reflects the vehicle's loss in value before and after the crash. A repaired vehicle may still be worth less because it now has an accident history. That is called diminished value. This can matter more when the repairs involved frame damage, structural repairs, major paintwork, or a commercial vehicle. Before you push back, check anything you signed. Some releases settle only property damage. Some settle only injury claims. Some try to settle all claims from the crash. The written release matters more than what an adjuster said on the phone. You should also organize proof. Gather repair estimates, final invoices, photos, rental records, the repair timeline, market value information, diminished value reports, insurance payment records, deductible information, and any subrogation or reimbursement letters. If your own insurer paid part of the claim, ask for a written accounting showing what was paid, what was recovered, and whether your deductible or uncovered losses were reimbursed. Fault can still matter, especially in a multi-vehicle crash. And insurance negotiations do not automatically extend the deadline to file a lawsuit. In many property damage cases, that deadline may be 3 years. So if the offer is low, challenge it with documents, review any release carefully, and do not wait too long.